Well, while everyone was kind of reeling from the decisions made by the District Court in California and then the Ninth Circuit Court of Appeals on Thursday night, basically at midnight, on whether or not Donald Trump shouldn't have taken control of the National Guard in California and whether or not it needed to go back to Gavin Newsom, the Supreme Court was getting ready to drop quite the decision on us. And honestly, I gotta say, mea culpa, I'm really angry that I didn't find out about this until last night because this is a huge deal. So let's talk about what happened. Imagine you're laying there in bed, getting ready to go to bed, and all of a sudden your front door is smashed in. SWAT rushes in, flash grenades explode, and FBI agents have stormed your house. And you're all sitting there at gunpoint only for them to realize, oh, this is the wrong house. Well, this may sound a little bit like the Breonna Taylor case, but this is different. So this is what happened to Curtrina Martin in Atlanta in 2017. So this happened 8 years ago. So after this botched warrant, and they were actually looking for their neighbor. So what happens next? Well, Curtrina filed a lawsuit against the federal government under the Federal Tort Claims Act, or the FTCA, seeking accountability for assault, battery, false imprisonment, and negligence. And this is going to be a big deal, guys. Now, let me explain what the FTCA is. So the FTCA is a federal law that actually allows people to sue the government for certain wrongs committed by federal employees, like the FBI or other law enforcement agencies. It is a narrow exception to the federal government's usual immunity from any lawsuit. It especially takes place when agents act recklessly or intentionally harm innocent people. They argued that the FBI's botched raid was exactly the kind of case the FTCA was meant to address. However, the Northern District and the Court of Appeals said no. The Northern District said, and their ruling, the ruling of the Northern District, is probably the more kind of understandable one, and I'll explain why. So the Northern District said that while the FBI's decisions were kind of questionable and they weren't great, they were still judgments. They were still acting in the course of their duty, and they fell under what's called the discretionary-function exception. This discretionary-function exception basically shields the government from lawsuits over decisions that involve policy or judgment calls. A judgment call like how to conduct a raid. The district court agreed and dismissed the case, saying the FBI's choices, even if negligent, were discretionary and thus made them immune from the suit. This is where it gets kind of surprising. When the Martins appealed to the 11th Circuit said, we agree, but also your lawsuit is barred by the Supremacy Clause. Now, the Supremacy Clause is a clause in the United States Constitution that says federal law always trumps state law. And this is where the Supreme Court's decision comes into play. Writing for the court, Gorsuch laid out a clear rebuke for the 11th Circuit. Basically, kind of, in my opinion, kind of calling them idiots. So the 11th Circuit had argued that because the FBI's actions were tied to federal policy, the Supremacy Clause blocked any state law-based claim. And here's why that's dumb. Gorsuch points out that the FTCA itself is a federal law, and that federal law explicitly creates the ability to have lawsuits under state law. So the FTCA says if you could have a law, or if you could have a lawsuit under state law, then it's okay to have it in federal court. It's sort of like the Erie Doctrine, which I won't go into here. And what's even crazier about this is during oral arguments for this case, the government's lawyers said, absolutely, the 11th Circuit got this wrong. Yeah, they're right. This is absolutely allowed under the FTCA. So after this, the court tackled the discretionary function exception. So after Gorsuch basically says the 11th Circuit's wrong about the FTCA, he goes even further and looks at their decision on the discretionary function exemption and rebukes them again. So the 11th Circuit had basically interpreted the this exception that blocks the lawsuits so broadly that it would be impossible to get any lawsuit in. The 11th Circuit was clearly acting for the government here. Like it blows my mind that anyone could say that a negligence claim would not be able to come into the courts here. And that's what the 11th Circuit was saying. And Gorsuch, writing for the court again, says, no, absolutely not. Now, here's the problem. The Supreme Court did not say, you are completely wrong, we find for the family. What they did was they sent it back to the 11th Circuit to basically be redecided using the new standard that the Supreme Court gave them. So we still have to see what's going to happen. I am definitely interested in this case. I'm also concerned because the 11th Circuit, that's Alabama, Georgia, and Florida, we're supposed to have competent, intelligent judges. And even all the dumb ones we've got in the Federal Circuit in D.C., they're still good jurists. They still know the law, and clearly know how to bend it to get what they want. So either we've got really, really dumb judges on the 11th Circuit, or we should all just be concerned that judges don't care anymore, which it kind of sounds like. Peace out, guys, and I hope you all have a great week.